The origin of land law in Malaysia can be traced since before independence. Before Malaysia achieved independence in the year 1957, Malaya or Tanah Melayu is comprised of these following entities: the Strait Settlements, comprised of Singapore Island, Penang Island, and the states of Malacca, while Federated Malay states comprise of Perak, Selangor, Negeri Sembilan, and Pahang, and as for unfederated Malay states comprised of Johor, Kedah, Perlis, Kelantan, and Terengganu. Each of these states used to have unique land tenure regimes that prevailed in their own territories. The idea that one who fells the trees owns the land was being practiced in Malaya before the year 1400. According to the custom, anyone who cleared wasteland was considered the holder of the land tenure as long as they also planted crops on the cleared ground and gave 1/10 of their harvest to the Sultan or the state authority. The land will revert to the ruler or the state if these two requirements are not met. However, with the arrival of Islam in Malacca, the affairs pertaining to the Malays' land were governed by Islamic laws land tenure laws between the year 1400 and 1786. Local customs were nevertheless followed and eventually turned into law in Malaya. The court in few cases had upheld that Islamic law was the law of the land. It can be illustrated in the case of Rama against Latun and Fatimah binti Hanis against Haji Ismail bin Tamim.
The Strait Settlement comprises of Penang, Malacca and Singapore. In 17th century, the island of Penang was part of Kedah. In the 18th century, French Islam negotiated for a lease of the island. The Sultan was facing problems from the Siamese and the Bugis, hoped the British would render military assistance to Kedah against Siamese and the Bugis. Unfortunately, through deceits and threats, the Sultan had to give up the Penang Island and province Wellesley, signing of 3 separate treaties in 1786, 1797 and 1800. Malacca was originally ruled by Muslim Sultan from 1511 to 1641, was occupied by the Portuguese. After 130 years of occupation, the Dutch surrendered Malacca to the British in 1795. When English took over the reign in Malacca from Dutch, after the Anglo-Dutch Treaty of 1824, Malacca had already its lex loci, consisting of a blending of the Islamic law and Malay custom. What is lex loci? A Latin term meaning of law of the place. The principle that the law of the place giving rise to particular rights is the law that governs the rights of parties to a legal proceeding. In Malaysia, Islamic law and customary law were the law of the land long before English law became prominent as under the current system. According to the Federal Constitution, Islamic law is the matter falling within the state law at state lease, meaning that the state legislature are empowered to enact the law. Malaysia is a multi-ethnic and multicultural land with Malays, Chinese, Indians and Orang Asli indigenous people who all share a unique cultural identity and yet able to continue the practice of their respective traditions. Many of the beliefs and practices have developed as a result of multiple cultures and intermarriage among the cultures who settled in Malaysia. 2 types of land grants in Malacca which were recognized during the Dutch. The first one is that the grants to town land held under a title for which dealings had to be declared. Last one is that grants of country land which was held by concessionaires who were entitled to collect title from the occupier. Moving on to the principle of law. The first one is that the Indian Act was passed and known as the Straits Land Act, which provided for the establishment of a land office to issue titles and to register transactions for record purposes only, the collection of land revenue, and the surveys to be undertaken. The next one is that the Malacca Land Ordinance 1861 was enacted with the provision for a survey of customary lands and formalized the status of land held under customary tenure. Last one is that Section 99 of the National Land Code, Penang and Malacca Titles, amended Act 1965, specially provided for Adat Pepatih and Adat Naning lands to be protected. So, a brief explanation about Adat Pepatih is a customary practice among people in Malaysia, especially Negeri Sembilan State. It is an unwritten custom that has been inherited for generations since 17th century and is practiced to this day. Case of Ong Cheng Neu and Yap Cha Neu. The island was wholly inhabited when the British arrived. Therefore, it was really immaterial as to whether the island should be regarded as a ceded or newly settled territory because there is no trace of any laws having. So, this case also ended the long-standing controversy of whether Penang was ceded or settled, as the judge was deciding which law was applicable in deciding the case. In this case, we could see that English law was applied. So, English land law being introduced to Penang by the First Charter of Justice 1807, wholly subjected towards English land law as there was no form of local tenure. 3 charters of justice passed by the English Parliament. The first one is that the first was in 1807, soon after the accusation of Penang. The second in 1826, after the accusation of Malacca and Singapore. And the third one in 1955. So, this was suit for a proper construction of a will of the deceased, or you knew. The will in question was drawn in a style of an English will and was attested according to English law.
To understand better the history of Malaysian land law in strait settlements, here are some examples that we can look at. Up until the year 1837, the land in Penang was held upon the following tenures: verbal licenses granted by Francis Light, cutting paper, measurement paper, official grants in writing in fee simple, and long occupancy of land seized without any regular permission. Even some parts of Malacca practice a system of land tenure similar to Adat Perpatih in Negeri Sembilan. This tenure, which is sometimes also known as Adat Nani.
Now let's go to the Federated Malay States. Before the Federated Malay States officially came into existence, according to the Bangkok Treaty, the Sultan of Perak will be advised by a British resident on all issues pertaining to the general administration, such as upholding peace and security, monitoring the collection of tax income, and promoting economic development. Thus, the residential system featured British supervision over all facets of the government aside from those pertaining to Islam and Malay traditions. The pact marked a formal break from the British government prior official position of not interfering in the affairs of the Malay kingdoms. Around the same time, similar treaty agreements were made with the rulers of Selangor, Negeri Sembilan, and Pahang, each of whom accepted a British residence. Now, through the Treaty of Federation, the Federated Malay States officially came into existence on July 1st, 1896. It is uniting the 3 neighbouring states of Negeri Sembilan, Selangor, and Perak on the western side of the peninsula, and Pahang on the eastern side. Kuala Lumpur was designated as the administrative capital of 4 British protected states. The United Kingdom was in charge of defence and foreign policy, and a federal council led by a British High Commissioner and assisted by a Resident General oversaw the Federated Malay States. Each state was divided into districts for administrative purpose, and these districts were overseen by British district officers. Now is for the principles of law. The Federated Malay States were where the torrent system was originally implemented. A Malay custom and Islamic law-based system of land law already existed at that time. The General Land Regulation, Perak, Selangor, Negeri Sembilan, and Pahang Land Enactments of 1987, as well as the Registration of Title Regulation Enactments, are all established the torrent system. For the side notes, torrent system was introduced by British colonial rule by W.E. Maxwell in Selangor after he came back from Australia to observe the land tenure there. He was appointed as the British resident in Selangor in 1889. Next, for the case law. According to Tengku Jaafar and another versus the state of Pahang in 1987, The Islamic law of the Shafi'i school served as Pahang's land law prior to the implementation of the torrent systems.
Moving on to the example to illustrate the principle of law that is being practiced in the Federated Malay States. It can be illustrated in the case of Sheikh Abdul Latif and others against Sheikh Ilyas's books. So when it comes to a Muslim who lived and died in Singapore, the court had to decide which law should be applied to the establishment of British influence on state administration. The rules also include they must be officially acknowledged by their rulers, which is the only law that existed, and the population of these states, Federated Malay States, was predominantly Mohammedans, Malays prior to the first treaty, which is Pangkor Treaty 1874, with a sizable Chinese mining and industrial presence present. Mohammedan law, as amended by local custom, was the sole law then that applied to Malaysians.
History timeline of the unfederated Malay states. Compared to the four federated Malay states, British influence arrived later in the five unfederated Malay states, which are Terengganu, Johor, Kedah, Perlis, and Kelantan. Beginning in the year 1912, the land enactment was implemented in the five unfederated Malay states. The northern states, Kedah and Perlis, were influenced by Siamese, and to a lesser extent, so were Kelantan and Terengganu. Due to the Anglo-Siamese Treaty, the British took control of these four states from Siam in the year 1909. The effect of such treaty was that a British advisor was appointed to look after British interests in each of these states. Also, Johor, which is the last state to come under British influence, accepted the status of a protectorate in the year 1914. Principles of law in regards to the unfederated Malay states. English torrent system was introduced gradually in the five states such as Land Enactment 1910 at Johor, Land Enactment 1906 at Kedah, Land Enactment 1926 at Kelantan, Land Enactment 1929 at Terengganu, and Land Enactment 1938 at Perlis. It is a system of registration of title and dealings of a land. The system is simple, and the title of interest to a land depends upon registration. However, it was abolished due to many issues of fraud through enforcement of National Land Code 1965, which the aim of introducing a uniform system of land law and registration of titles in the whole of Peninsular Malaysia. It is of considerable importance to note that the National Land Code 1965 was passed by the Parliament by virtue of the power given under Article 76, Clause 4 of the Federal Constitution of Malaysia for the purpose of ensuring uniformity of law and policy on land matters. Example of law cases that is in relation with unfederated Malay states. The system of registration of title and land dealings contained in a codifying enactment does not permit the application of the doctrine of English equity to land matters. This is as shown in the case of Davy versus Francis, whereby the court held that Section 6 of the Civil Law Act 1956 prohibits the application of English law and the rules of equity relating thereto in Malaysia. However, English equitable principles of general application, to the extent that they are not inconsistent with the general framework of the torrent system as embodied in the National Land Code, are applicable to land matters in Malaysia.
For further illustration, it can be seen in the United Malayan Banking Corporate and Honor against Pemungut Hasil Tanah Kota Tinggi. To quote Lord Keith of Kinkle, he stated that the National Land Code is a complete and comprehensive code of law governing the tenure of land in Malaysia, and the incidence of it, as well as other important matters affecting land there, and there is no room for the importation of any rules of English law in that field except insofar as the National Land Code itself may expressly provide for this. To conclude our video, these are the land law administration that is currently being used in Malaysia. First, National Land Code 1965, which is only applicable in Peninsular Malaysia. Second, Sabah Land Ordinance that governs the lands in the states of Sabah. And finally, Sarawak Land Code that governs the land in the states of Sarawak.